In this presentation, we will study the United Kingdom new regulation called the Bribery Act. The Bribery Act was adopted by the UK Parliament on the 8th of April 2010. The law was quickly completed by a governmental guidance issued by the Ministry of Justice. The Bribery Act came to force on the 1st of July 2011. We will briefly review what is really new in this UK regulation in comparison with the existing international treaties and other regulations against corruption. The UK Bribery Act contains in its Section 7 a new corporate offence, introducing criminal liability on corporate bodies that fail to prevent bribery. Consequently, companies have major incentives to put in place adequate procedures. What kind of procedures shall companies put in place? First of all, the procedures must be adequate. That is to say, proportionate to the level of risk. It is not a matter of the company size. It mainly concerns the countries where the company operates and the person with whom the company deals. Bribery may be direct or indirect. That is to say, directly between the company and the official, or indirectly through a third-party agent. Companies are expected by the Bribery Act and guidance to audit their business. They should, therefore, ask themselves the following types of questions. Does the company deal with local public officials or foreign public officials? Does the company use third-party agents to obtain new contracts? Is due diligence in use inside the company before establishing a partnership? Then, thanks to these self-assessments, the companies will draft a risk assessment in order to estimate potential internal and external risk of bribery. Efficient procedures and clear assessments are requested by the law. Top-level commitment. The top-level management must foster a culture within the organization in which bribery is never acceptable. Tolerance zero. A correlation between bribery and getting fired should be made by the companies. Code of Business Conduct Handbook, Gift and Hospitality Policy, Ethics Policy, Procurement Policy, Data Privacy Policy, IT Policy, Group Approval Process, Disciplinary Procedures, Fraud Policy, and so on. But the anti-bribery program must also be efficient. Not only assessments, but tools and procedures. The company must implement trainings in seminar or classroom format dedicated to employees and associated persons, e-learning session, regular information, regular monitoring of the procedures included in the various handbooks, escalation procedures, whistleblowing speak-out program, regular monitoring on the activity, compliance officer appointment, and so on. The enforcement of these statements and procedures will be checked and evaluated by the prosecutors. Who is concerned by this new offence? All companies having a demonstrable business presence in the UK. So all companies incorporated or having a partnership formed in the UK are obviously addressed by the law. Are also addressed all companies in the world carrying on business or a part of business in the UK, irrespective to the place of formation or incorporation. There is no requirement of a close connection with the UK, such as UK nationality, UK residence, or incorporation in the UK. Guidelines affirm that the court will be the final arbiter as to whether an organization carries on business in the UK. Associated person. A commercial organization is liable under Section 7 if a person associated with it bribes another person. The person considered to be associated is someone who performs services for or on behalf of the organization. It could be an individual or a company, irrespective of the place of incorporation. So it could be employees located in a foreign branch. Indeed, employees are always presumed to be performing services for their companies. It can also be agents and subsidiaries. But other situations have to be tackled. Contractors. They may be considered as associated persons when, instead of simply selling goods, they act on behalf of the parent company. Contractors and subcontractors. The guidelines underline the fact that the parent organization is likely to have more influence on its direct contractors than on its subcontractors. But, as the text of Section 7 is quite broad, companies are expected to advise their contractors to put in place anti-bribery procedures. These contractors will then advise their own contractors to do the same in order to provide protection at every possible level against a possible prosecution based on Section 7. Joint venture acting in a separate company. A member of a JV may be liable for failure to prevent bribery if the JV is performing services for that member and gives a bribe with the intention to benefit that member. If the bribe only benefits to the JV, members won't be liable for it. Joint venture conducted in a contractual arrangement. The degree of control that a member has over the arrangement is a relevant information in order to decide if a member has performed a service for the JV or in the name of the JV for its own interests or for the interests of the JV. Today, corruption has reached a high level of complexity, using financial, IT, and intelligence networks to operate. Consequently, the examples we have just studied are far from reality. The number of parties involved in a massive corruption system is often huge, and networks are very difficult to identify, as they are often using tax haven and money laundering. The judge has the full power to grant a non-defined fine. This could lead to very severe sanctions, as the fault for not developing a compliance program may not be the cause of the bribery. The Serious Fraud Office. The main prosecution authority in the UK regarding the crime of bribery is the SFO, Serious Fraud Office, which operates in England, Wales and Northern Ireland. The Serious Fraud Office developed an international intelligence strategy with, most notably, the United States Department of Justice and the Securities and Exchange Commission, but also through international and European networks such as Eurojust, the International Association of Prosecutors, and the World Bank. In practice, prosecutors can refer to the Crime and Courts Act issued in 2013 and analyze if a deferred agreement is possible. A DPA is an agreement reached under judicial supervision between the prosecutors and an organization. It may be appropriate where the public interest is not best served by mounting a prosecution. For example, we can mention cases when corruption is not too expanded, or when the prosecution involves national security, or when the organization fully cooperates with the Serious Fraud Office. The agreement allows the prosecution to be suspended for a defined period, provided the organization meets some specified conditions. Conditions attached to the DPA may include disgorgement of profit, payment of a fine, compensation for the victims, cooperation in any prosecution of individuals, implementation of compliance program with, if necessary, the appointment of a monitor. However, entering into the agreement will be a fully transparent public event. Conclusion. With Section 7 of the Bribery Act, the United Kingdom has developed a clear strategy of self-defense, putting companies all over the world under the constraint to develop a program against corruption. In this way, Section 7 is very similar to an antivirus software. As a conclusion, we can mention around 15 ongoing investigations by the SFO against companies, but no prosecution until now. In the following slides, you will find examples highlighting the extraterritoriality situation. Keep in mind that courts will grant their decision regarding the degree of control of the organization, the intention of the person or entity who committed the bribery, the common sense approach. Case 1. A big company is incorporated in the UK. One of its subsidiaries is located in France. Neither the UK nor the French companies have put in place a program against corruption. A bribe is paid in France by an employee of the French company to a local public official in order to retain a local contract. The UK company has a high degree of control on the subsidiary. Top management is appointed by the parent company, who gives authorizations to bid. Will the UK and French organizations be sentenced? The answer is yes. The same UK company is under negotiation with a worldwide company incorporated in Marketland. This company has a subsidiary in France. In case of success of the negotiations, the French subsidiary will operate a new contract. A bribe is paid by an employee of the French company to a foreign public official in Marketland in order to obtain an official agreement. But the UK company has developed an anti-bribery program in accordance with the guidance principles. Will the UK and French organizations be prosecuted? Yes, both UK and French companies are likely to fall under Section 7 of the Bribery Act because the French company is an associated person and the UK company failed to prevent bribery within the group. Here, the situation is different. A French incorporated company has a branch in England. A French employee of the French company paid a bribe to the government of Marketland in order to gain a new contract for the sole benefit of the French company. No compliance program was developed in the UK or in France. Because the French company has a demonstrable presence in the UK, the Serious Fraud Office could investigate in the UK and in France. Will the UK and French organizations be prosecuted? Yes. In this case, the UK and the French companies are not part of the same group. They merely have commercial relations as the French company sells goods to the UK company. The French company is dealing with an agent who bribed a local official. Will the UK and French organizations be sentenced? The answer is no. In this example, there is no common project between the two partners, and none of them is acting for or on behalf of the other. The French company is not an associated person. Case 5. In this case, the UK company has a branch in France. Both have put in place anti-bribery programs in accordance with the Bribery Act and guiding principles. A bribe has been paid by a French employee to a local public official. Will the UK and French organization be sentenced? No, because they have put in place anti-bribery procedures. They can use these procedures as a full defense against prosecution based on Section 7 of the Bribery Act. This is the end of the training. Thank you for listening to Telex. Goodbye.